Well, good morning, everybody. Morning. Welcome to the best law school in Brooklyn. You know, an alum recently said I should say with the Harvard of Kings County, but I'm not sure that Harvard is ready or deserves the compliment, you know? So we're not going to go with that. Some of you may have read in the New York Law Journal, which is not fake news. I mean, it's a serious publication that they rated Brooklyn Law School as the second best overall law school in New York. So, you know, you can pick and quibble with rankings and ratings, and I have, but that's better than a poke in the eye with a sharp stick. And while that indicates we still have a little bit of work to do to overtake NYU, I am very proud of that, and I think it is particularly gratifying because it's based on customer satisfaction. It's based on a survey of employers, prosecutors, public defenders, graduates, and so on. So I'm very happy with that. Well, I'll tell you, we may be the best second best overall law school by some people's consideration, but our criminal justice, criminal law faculty and offerings, which bring you all here today, are second to none, and I mean that in every sense of the word. So we're very happy to have you here. Before I continue, just two housekeeping items. Number one, you know that food and drink are technically not permitted in this room, but given the audience here, and that so many of you, including me, are in flagrant violation, I think that we are going to choose not to prosecute lower-level crimes today. So don't tell anybody. I mean, it's just before us, a couple of people here, but enjoy yourselves and have a very productive day. Second, I'm very aware that some of you may find it a little chilly in here today. We'll do what we can with our ancient heating system. Ordinarily, what we rely on, because we have lawyers in this room, is for the natural warmth of people's expression to heat up the room as it goes on. But you might be interested to know we are frequently a location for television and films. And a day and a half ago, Alec Baldwin was in here in this room filming the upcoming DeLorean movie, and he was wearing very, very, very heavy makeup, a big, bulbous nose and so on, heavy stuff. And he apparently insists that his filming locations be like Antarctic-like. So we got it down to suit him, and we haven't yet quite succeeded in getting, our furnaces restoked and up. So please just bear with it, and I apologize if there's any discomfort. So this is the 30th anniversary of our criminal law procedural and evidence CLE program, and it was the brainchild of the much beloved and very effective late Professor Robert M. Pitler, Pitbull Bob, that many of you I'm sure know. He took great pride in our criminal justice offerings and the strength of his colleagues on the faculty. He took great pride in this program. And when he passed away 2 years ago, that loss had us scrambling, but we're extremely fortunate and happy that Judge Barry Kamens has stepped in, who, by the way, was a dear friend and colleague of Bob Pitler, and I'm very pleased to say he's a personal friend and great colleague of mine, and I see him everywhere in Brooklyn at every occasion where, if there's two lawyers, one of them will be Barry Kamens. So I'm really happy that he's stepped in such a way and will be leading this program. It's really fitting, as I said, that this takes place at this law school. Across the street, we have a progressive district attorney's office. I think the most, if not one of the most, progressive district attorney's offices in the country. We have the public defender's offices, the local bar associations, and here, this law school is the center of learning how to use the power of law to advance justice, particularly in the criminal law field. So it's very appropriate that you're all here today. It's remarkable there's so many people. This courtroom, which seats 375, is almost full, and I'm sure it will be while some stragglers come in. I wish for you that it was raining cats and dogs so you didn't feel so bad being indoors, but I assure you that you're going to find at the end of the day that the program is substantive and worthwhile. I also want you to know that the fees that we collect, the proceeds from this important program go for a very worthy cause, and they go to fund the postgraduate criminal justice fellowships that Professor Pitler established, and therefore alumni of this law school who work 5 or more years in criminal justice positions, and it helps to support their commitment to that line of work. So it's a very important cause that you're all serving, not only by learning and keeping up to date with the latest cases, developments, rulings, procedures, and so on, but also by supporting people who want to follow your example and engage in this field. This is a moment when I'm reminded that the one reason some people think it's the main or only reason for a law school having a dean is that without a dean, if you didn't have a dean, you couldn't have an associate dean. So I am going to introduce and hand over to you the one, the only, the incredible Associate Dean, co-director of our Criminal Law Pitler Center, and Professor Stacy Kaplow. Stacy.
Well, what can I say? Thank you very, very much for those kind words, and I also just want to echo a welcome to Brooklyn Law School, and for those of you who've been a regular participant in this program, we're really glad to see you again. There was a period of time where after Bob Pitler's death, where we weren't sure this program would continue, but as you know, and as the Dean just mentioned, we've got a fabulous recruit in the form of Judge Kamins, who is a partner at Adala, Bertuna, and Kamins, and a retired Supreme Court judge, and the former administrative judge of the New York City criminal courts. We also have the good fortune of having him on our adjunct faculty, where he teaches a course in New York criminal practice. So we're lucky that he is so well connected to the criminal justice world in New York City that we have such a terrific lineup of speakers and terrific materials to be able to hand out to you. I wanted to acknowledge, in addition to Judge Kamins, the people who contributed to making today run so smoothly so far. Matilda Garrido, who is the director of our CLE programs, Liz Alper, who is in our events office and who's responsible for coordinating all of the movement and the aspects of today's program. And we have 4 Center for Criminal Justice Fellows who help to prepare the materials and who are also present to help you and to make sure that you get where you need to be and to hold mics for your questioning and things like that. And all of the other staff from the law school who got up early this morning to get us started.
And Stacy, I forgot. I meant to introduce you all to the newest member of our criminal law faculty, and she may be here. I just haven't seen her. It's Kate, Professor. Oh, there she is. Stand up and now welcome. Give a big round of applause, Kate Mogilevsky. She is amazing.
Yeah, and Kate has joined our already strong criminal law faculty here, and will be starting a criminal defense clinic in the spring, so we're just thrilled that she's here. And what kind of is a wonderful aspect of the day for me is that there's so many people here who I've known for a long time and get to hug and say hello to, both former colleagues at Legal Aid, the DA's office, former students, so it's great. We have a terrific criminal justice community. Let me just give you a little bit of traffic advice about the day for the purposes of CLE. If you're here for credit, which I assume most of you are, make sure that you actually have signed in downstairs, and if you haven't done that, feel free to just go to do that now and then come right back. The sign-in is going to close in about 15 minutes, so you don't want to miss that. If you need to stretch your legs or you want to go out and get a quick extra cup of coffee, you can go outside. The coffee setup will continue. There's TV screens out there. But part of the CLE is that you're actually continuously present, so watch the TV screens or the monitors and then come back in. There will, before lunch, we're going to stop about 12:45. Please make sure you're back in this room. I'm sorry, the afternoon session will start at 12:45, my mistake. Please make sure you're back in the room, and again, in order to log in your CLE time. Finally, the most important thing, I'm sure, for all of you, don't forget to sign out at the end of the day and to turn in your evaluation form. If you don't sign out, unfortunately, we can't give you the credit. You will receive a certificate for the credit in the mail or by email after today. You don't have to wait around and get a certificate. So with all of that housekeeping business out of the way, and just so that we can get the day started, I'm going to turn the floor over to Judge Kamens. And thank you again for being here.
Thanks. Happy anniversary. Good morning, everyone. I thought I would begin the review of search and seizure with talking about what's happening at the United States Supreme Court level, and I thought I would begin with three cases. One case that has not been yet argued, which is probably the most important case, one case that was argued and not yet decided, and one case that was decided. The one that has not been argued is probably the most important search and seizure case to come down in a number of years. It comes out of the Sixth Circuit. It's United States versus Carpenter. It's not in the outline because, as I said, it has not been yet argued and certainly not decided, but I wanted to mention it anyway, just to so you'll keep your eye out for it. The Supreme Court granted cert in this case of most importance, and it has to do with cell site location information. Those are, of course, as you know, records that are obtained by the prosecution from the defendant's cellular service by a court order under the Federal Stored Communications Act. Now, this is the first case taken by the Supreme Court dealing with cell site location information, and the court is being asked to rethink, as part of this issue, whether or not the third-party doctrine should be revisited. And under that doctrine, records are not protected under the Fourth Amendment because an individual has no privacy interests in records that are kept or maintained by third parties, and here the third party would be a wireless carrier. So the issue will be whether these records are protected by the Fourth Amendment and therefore whether a warrant should be obtained or whether they can be obtained by a court order under the Federal Stored Communications Act. Now, these records generally establish the location of a phone and, by inference, the location of an individual, usually the defendant, at a given point in time by reference to whatever cell tower sent and received signals from the defendant's phone. So essentially, it's an electronic communication between the cell phone and a cell tower. In Carpenter, the police obtained cell site records from Carpenter's cell phone provider. And these records spanned a considerable amount of time. It was 4 months. 4 months of his activities, and the information revealed that his cell phone was near the scene of several crimes, and eventually, based upon, partially on that information, he was in fact convicted. The police did not have a search warrant, but applied, again, for a court order under the Stored Communications Act. So the Sixth Circuit rejected the defendant's motion to suppress, holding a number of things. It distinguished between constitutionally protected content information and non-protected, what they call routing information, and holding that cell site information, location information, is routing information. And they held that the third-party doctrine is still the law until the Supreme Court tells us it's not the law, and that phone users have no expectation of privacy in locational information because users by now in 2017 should know that placing or receiving a call exposes the phone's location to the nearest cell tower's response. In New York, we have very little precedent. We have an old, 6 years old, case from the First Department, People versus Hall, dealing with that cell site location information, but that was a case where it was a 3-day period of time, and the court said even if a prolonged surveillance might require a search warrant, which they didn't reach, the records there only covered 3 days. So Carpenter obviously raises a number of important issues. Should the third-party doctrine be revisited? After all, it's 35 years old. Should it be reevaluated in light of modern technology? After all, it was created at a time when people still use rotary phones and did their research on something called the Yellow Pages. I don't know if any of you remember the Yellow Pages, but Justice Kagan had suggested in U.S. v. Jones that perhaps it's necessary to reconsider the third-party doctrine. At least one state, Massachusetts, has done that. In Commonwealth versus Augustine, this is what the highest court in that state said. The nature of cellular telephone technology and cell site location information and the character of cellular telephone use in our current society renders the third-party doctrine inapposite. And the digital age has altered dramatically the societal landscape from the 70s when Miller and Smith, those were the Supreme Court cases, were written. If you want the site on Augustine, it's 4 Northeast 3rd, 846. So, Supreme Court's going to have some interesting issues. Is location data different from content data? Is the collection of location data a search? And if it is a search, does that require a search warrant? The case that was, so that was Carpenter. The case that was argued and not yet decided was a case that was argued a few weeks ago, District of Columbia versus Wesby. It's a very interesting case because it involves the assessment of probable cause and what thought process a police officer should be going through in assessing whether he or she has probable cause to make an arrest. Here the police were called to a residence about 1:30 in the morning after they received reports of a group of people having a party in a home that was supposed to be vacant. When the police arrived, they were told by the partygoers that they had been invited by a woman named Peaches. Now, Peaches becomes very important in this case, and I imagine that's the first time the word Peaches was argued or mentioned in the United States Supreme Court, but she becomes very critical to the case. Now, when the police arrived, the electricity was off, they were using candles, and the police called Peaches, who well, she refused to come down to the location, but first told the police she had told the partygoers that they could use the home. And she first told the police that she had worked out some arrangement with the owner, but then recanted over the phone and said, no, we never really worked out a lease. Then they spoke to the homeowner over the phone who said, no, we never worked out, we had never reached an agreement on the lease. So the Circuit Court of the District of Columbia held that the police had no probable cause to arrest the partygoers for trespass, that the invitation by Peaches negated any intent by the partygoers to commit trespass. There was no intent. The officers never asked Peaches, as it turns out, or the homeowner whether the partygoers knew that Peaches had no right to be in the home. So the issue for the court when they decide this case will be in assessing probable cause, what weight must or should a police officer give a suspect or target who gives to a suspect or target who gives a credible claim of innocence. So I think it's going to be an interesting decision. Now, the case that was decided, which is on page 1 of the outline of the book, is Manuel versus City of Joliet, Illinois, where the Supreme Court elevated the importance of the Fourth Amendment by holding that the Fourth Amendment and not the Due Process Clause is the appropriate constitutional provision to assess unlawful detention after legal process has begun. Obviously, before legal process, we know it applies to the deprivation of liberty, but now it governs after a case has commenced. Now, the defendant in that case was held for 7 weeks in custody following an arrest which turned out to be based upon fabricated evidence. A clerk had lied about the results of a test that was given to the defendant. The Supreme Court held that a defendant may sue for a violation of his or her 1983 rights under the Fourth Amendment based on a lack of probable cause that results in custody after a case has commenced. So I imagine that will now impact on a number of the wrongful death litigation. So moving on to standing. On page 2, I believe we have Bushy, which is a case where the police were using a plate reader. They were reading plates and running it through, license plates, running it through a plate reader. The Court of Appeals said clearly a driver has no reasonable expectation of privacy and information provided by the DMV concerning his or her registration of a vehicle. nor has the driver any expectation of privacy in the DMV database itself. Therefore, a police officer may run a plate through a government database and check for any outstanding violations, suspended licenses, etc., and such a run does not constitute a search. Information provided from that run can provide probable cause. Lower courts had ruled on this consistently, but this is the first time the Court of Appeals got around to deciding this issue. Now, this is consistent with the court's position taken years ago. You may remember a case, People versus Tolentino, in which the court held that a motorist has no expectation of privacy in DMV files, holding in that case, even if an officer unlawfully stops a vehicle, a motorist cannot suppress information, such as information about a suspended license, where the officer was able to access these pre-existing records merely by getting the name of the individual who he or she has unlawfully stopped. So Bushway says, the bottom line is, while an officer cannot arbitrarily stop a car for the purpose of running the plate, there's no problem in the officer doing that while he sees the car on the road or on a highway and running it from his vantage point. One other standing case on page 2 is a People versus Dent coming out of Supreme Court in Queens, where a judge decided a case of first impression in New York. If a police officer recovers a credit card from a defendant and then swipes the card through a magnetic swipe reader, is that a search? And does the defendant have an expectation of privacy in the information contained in the magnetic strip? The answer to both of those questions was no, according to the judge. The court relied on federal decisions from other states, holding that using a magnetic strip reader does not constitute a physical intrusion into an area protected by the Fourth Amendment, analogizing it to using an ultraviolet light to detect whether a bill is counterfeit or not, or testing whether a knife can be opened by the force of gravity. By the way, the gravity knife bill, you should know, that was not enacted, it was not signed by the governor, it was vetoed for a second time this year. And the court in Dent also held that there's no reasonable expectation of privacy in this case because the holder of the card has knowingly disclosed information to a third party, the financial institution. Again, the third party doctrine, again, that's why Carpenter, I mentioned before, will be so important. Okay, so let's get to street encounters. So of course we go back to Bourgh. And reading a number of the cases recently and over the last few years, I think it's fair to say that the level that presents the most difficulty for courts, for prosecutors, for defense attorneys is that second level, the common law right to inquire, and what is a founded suspicion of criminal activity. It's become even more of a challenge, I think, in these cases because the court a number of years ago in Garcia extended Bourgh to automobile stops. So the question then is, what questions can you ask of a motorist under level 2? You can ask accusatory type questions, but getting to that level and understanding it is a challenge. One of the factors in the equation under a common law right to inquire is this factor of nervousness or nervous activity on the part of passengers and drivers who are stopped and individuals who are stopped who are on the street. So I just wanted to point out 3 cases in the outline. The first is the Freeman case on page 3. The defendant here was stopped for riding a bicycle without a light. The defendant was, according to the officer, was shaking, nervous, appeared nervous. The court said this in and of itself certainly would not, this nervousness would not create a founded suspicion of criminal activity, justifying any accusatory type questions. The Gates case on page 3, the defendant was pulled over for speeding upstate New York on Route 81. The troopers observed several bags, nylon bags with sharp edges behind the driver's seat. The driver asked the defendant where he was going. He said he and his passengers had been to Ohio. They're coming back. They visited family. The trooper then noticed that the defendant and the passengers appeared nervous. Then the trooper asks, "What's in the bag? Is it luggage?" The defendant then gave a series of answers, changing his answers. First it was clothing, then it was presents, then it was riding toys, then it was bicycles, Then he said, no, I'm sorry, it's untaxed cigarettes I got from an Indian reservation. So the court held in that case the accusatory question that led to the series of contradictory answers should never have been asked in the first place, that the nervousness of the defendant and the passengers did not justify the accusatory question, and the cigarettes were suppressed. Case number 3, I jump into the outline, into the automobile section of the outline. It's page 15, People versus Williams, coming out of the 4th Department. After a valid VTL stop, a passenger was patting his pocket, shaking, and appeared nervous, according to the officer. The officer asked this question, quote, "Why are you nervous?" Close quote. Now, how many of you think that that's an accusatory type question? How many of you don't? How many of you don't care? It's hard to tell early in the morning, people are not. Well, for those of you who thought and reasonably thought it was an accusatory type question, the 4th Department disagrees with you. The question, they said, is not accusatory in nature, did not exceed a request for information that was non-discriminatory. The passenger said in answering that question, quote, "I'm not going to lie, I've got a little bit of weed on me." Well, you know what happens after that. There's this follow-up. I mean, the equation then changes, and you know where this leads. This leads ultimately to an arrest, which was valid, but the point being the question itself was not accusatory, therefore it was a valid question by the officer. One more common law inquiry case I want to point out on page 4. The Court of Appeals affirmed that appellate division decision on page 4, the Simmons case. It upheld a level 2 request for the defendant to show his hands, which is a level type 2 protective measure that's okay. If the facts justify it, the facts did justify it. The defendant was clutching his waistband. It was a high crime rate area. There were recent reports of gunshots in the area where the defendant was, and the officer testified he had made many arrests involving weapons in this type of situation. So that was valid. Now, Bourgh has been around for 40 years, and it's governed, obviously, interactions between citizens and the police on the street. I would say over the last year or so, the battleground of Bourgh has really moved from the street into buildings, public housing buildings and trespass affidavit buildings. That's really where the law is really being made now. And an excellent example of that is the Hill case on page 5. Now, we know that the primary goal of police activity in these buildings, as they testify to, is to locate trespassers. And they conduct, in finding trespassers, they conduct routine vertical patrols. And while we have the benefit of 40 years of decisions of Bourgh out on the street, we're just now seeing a body of law that's being created dealing with encounters. We're not there yet. There's certainly a lot of questions that are unanswered, but it will be developed over the years ahead. One important question that is still being litigated is how far under Bourgh can an officer go to conduct into an investigation to determine whether someone is or is not a trespasser. Courts generally have condoned what they've defined, I guess, or delineated as a brief investigation to determine whether an individual's explanation for being in the building is a credible one. And typically a person will tell an officer that he or she is visiting a friend or a relative, or that he in fact or she lives in the building. So what actions can the officer take to corroborate that? Or determine that they're not true and then make an arrest for trespass. So in Hill, the police were patrolling near a NYCHA building up in the Bronx. They're on the roof, looking down. They see the defendant coming into the building, coming out, coming in, about four times in a very short period of time. They radio the officers downstairs. Those officers approach the defendant outside the entrance and ask the defendant what is he doing in the building. He says he's visiting his girlfriend in an apartment and she lives on the 11th floor. Fine, they said, great. Can we see some ID? He gives them his ID voluntarily, no coercion. They say to him, stay here with some of the officers if you will. We're just going to go upstairs. We're going to take your ID, go upstairs and confirm it. And There was no objection from the defendant. They go upstairs, knock on the door, they show her the ID. I've never seen that person before. I don't know who he is. And they go down and they make the arrest for trespass. And then pursuant to the arrest, there are 42 bags of cocaine on him. So the issue for the court was, and what caused one judge to dissent, was whether the officer's retention of the defendant's ID was a seizure. And the court noted, well, look, in the past, we've permitted this brief investigation by allowing the police to do a number of things which we have held in the past is not a seizure. We've condoned allowing the police to tell a person to remain in the vestibule while we go upstairs, in some cases, asking the individual to come with them upstairs. So if the court said, if we held that that's not a seizure, certainly allowing the police to take the identification and keeping the defendant downstairs was not a seizure, and therefore the arrest was valid. The court noted that the defendant voluntarily turned over the ID, did not object to it, and the retention was brief. Of course, in the next case, the individual will say, I don't want to give you my ID. You know, so as you can see, this is an evolving area of the law, but we'll see where it goes. In the area of arrests, I want to mention a case that was decided Tuesday by our Court of Appeals, the Garvin case on page 8, which is has the appellate division site. Now, last year I mentioned, I spoke about a case decided by the Second Circuit, United States versus Allen, in which the court found a Payton issue, a Payton violation, even though the police had not crossed the threshold. The Second Circuit held in Allen that there can be an across-the-threshold arrest which violates Payton, where an individual answers the door after a knock on the door, and the officer informs him that he is under arrest, where the officers have not crossed the threshold. And they joined a number of other federal circuits, although it's certainly not unanimous, it's divided among the circuits. But they joined some other federal circuits in holding that. On Tuesday, in Garvin, the Court of Appeals declined to follow Allen. It upheld an arrest by the police, quote, at the doorway. The police knocked on the defendant's door. He came to the door, and he was arrested at the threshold while the police did not cross the threshold. The majority, a 5-2 decision, held that the court was adhering to prior decisions by the court that there can be no Payton violation if the police do not cross the threshold. They continue to adhere, they said, to this bright line rule, and yet, after one reads this 75-page decision, they did not define yet what they mean by threshold or doorway arrest. So Payton cases continue to rest on a theory really of inches, on the doorway, at the doorway, in the doorway, at the threshold, without much clarity from our highest court. I think Judge Dwyer, who will be here in a little bit, probably took a stab at it and did the best job of defining doorway as the distance between the door jambs. But you can see it's really, as they say in sports, a game of inches. And in his dissent, Judge Wilson opined that the federal and state constitutional protections should not turn on such a fine line. So, but as I say, he was in dissent. Now, so there's a disagreement now between our Court of Appeals and the Second Circuit. This is the second time this year that there's been a disagreement in search and seizure, and I'll mention the other one a little bit later. That has to do with searches incident to an arrest. One other case involving arrests as far as excessive force, People versus Hill on page 8. This is the first time an appellate court has discussed the use of a canine in effecting an arrest and whether that constitutes excessive force. This is a scenario where the officer is chasing an individual, has a dog with him, trained to do that, and uses the dog, releases the dog, and the dog brings the suspect down during the chase. The court said that the use of the dog does not elevate reasonable suspicion to an arrest, and that the use of the dog is not excessive where a number of conditions are met. The defendant continues to run after an officer IDs himself, and the officer repeatedly orders him to stop, and the officer warns the defendant, if you don't stop, I'm going to release Fido, whatever the name of the dog is. Well, Fido doesn't sound too aggressive, but I'll release the dog. So if those conditions are met, the dog can be released. It's not excessive force, and that so holds the First Department. Some say it gives one pause, but I won't. Okay. So everybody's still asleep here, I see. Okay. So search warrants and the exceptions to the requirement for search warrants. So, of course, the case that was supposed to be the seminal case was a case coming out of the Court of Appeals on page 9, matter of 381 search warrants directed to Facebook. Now, this was much anticipated, probably the most anticlimactic case coming out of the court this year. Social media companies and civil libertarians were hoping that the court might create new legal guidelines for search warrants aimed at social media services. And this was going to be the seminal case. But as you probably know from reading it, the court was constrained to adhere to the very narrow procedural framework of the case and could not address the broader issues. So going back to where this all started, this was a case that arose in New York Supreme Court. Judge Jackson, who granted an application for search warrant for 381 search warrants to Facebook pursuant to the Federal Stored Communications Act. And the warrants were issued in connection with a criminal investigation by Mr. Vance's office into fraudulent disability claims by retired firefighters and police officers. So the search warrant authorized the seizure of 381 Facebook accounts of 381 subscribers. The texts, the photos, the videos, the private messages, and Facebook was even directed that they were not permitted to tell their subscribers that the warrant had been issued. So Facebook then moved to quash the search warrant. The Supreme Court denied the motion, holding that Facebook lacked standing. Facebook then appealed to the First Department, and the First Department dismissed the appeal, holding that social media services have no rights on behalf of a client to challenge a warrant served upon it before it is executed, either constitutionally or by statute. So the Court of Appeals then granted leave. And as tempting as it was, the court said, to reach the merits, the court was constrained to dismiss the appeal, holding that the CPL does not provide any mechanism for a motion by a third party, namely here Facebook, to quash a search warrant or for taking an appeal from the denial of such a motion. And the crux of the dispute was whether the warrants obtained by the DA were warrants or were they really subpoenas, as Facebook was arguing. Facebook argued they were subpoenas because it was a good reason to argue that, because a motion to quash a subpoena issued prior to the commencement of a criminal action commences a special civil proceeding, and an order resolving such a motion is appealable. But the court said because these really were warrants and not subpoenas, the orders issued by the Supreme Court were not appealable under the CPL. So the court said it's up to the legislature to change, if it wants, the current procedural scheme, and whether Facebook has standing and all those other interesting issues are left for another day. All right, so let's get to some of the exceptions to the warrant requirement, and I mentioned earlier the search incident to an arrest. 2 years ago, our Court of Appeals issued two decisions, Jimenez and Reed. In the Jimenez case, the court reminded prosecutors that they were really not eliciting sufficient information to establish exigent circumstances in many cases, which would justify a search of a container incident to an arrest. And just to go back to basics, under this theory, prosecutors must satisfy two requirements. The search may not be separated in time or place from the arrest, and there must be this presence of exigent circumstances, either the safety of the public or arresting officer, or the concern over the concealment or destruction of evidence. One of those two things needs to be elicited by the prosecutor at the suppression hearing. Since Jimenez, lower courts have been consistently applying Jimenez and in many cases suppressing because the prosecutor is not doing its job according to the court. So the first case is the Hinton case on page 10. Defendant's arrested, he's in handcuffs, 5 officers are standing close to him. He's got a shoulder bag that's described as being secured. The officer, according to the decision, does not state during his testimony that the defendant was uncooperative, that he posed any threat, that he was attempting to gain access or let alone to destroy the contents of the bag. In essence, there was no proof of any exigency, and therefore the court reversed the suppression court and granted the defendant's motion to suppress 15 counterfeit bills that were in the bag. The Houston case, or Houston case, on page 10, defendant commits a robbery on Flatbush Avenue in a convenience store. Store clerk points the defendant out on the street. There's a chase. The officer runs, chases him, catches him, finds a gun in his jacket, and then, as he's surrendering, he places a briefcase on a parked car. That briefcase is searched, and in the bag are the proceeds of the robbery. Again, the appellate division reverses the suppression court's denial of the suppression of the proceeds of the robbery, holding that the people failed to present evidence establishing exigent circumstances that would justify the search of the briefcase. No testimony was elicited, the court points out, from the arresting officer that perhaps he searched the bag out of a concern for his safety or the safety of the public, or that he searched the bag to prevent the defendant from destroying evidence. Nothing like that was elicited, therefore no exigent circumstances. And prosecutors are not the only ones who have been criticized on this issue of exigent circumstances. Towards the end of the outline, there are cases on ineffective assistance of counsel. On page 20, there's a case, People versus Schutscher, where the First Department held that if defense counsel does not argue a lack of exigent circumstances, that constitutes ineffective assistance of counsel. Now, I mentioned that our Court of Appeals has disagreed with the Second Circuit on one issue, that's the Payton issue. Now, the second issue is on searches incident to an arrest. And we start out with the Reed case that was decided in 2014. The Second Circuit case that disagrees with the Reed decision is on page, I think it's page 11. That site, by the way, now is 854 Fed 3rd 197. So let's go back to Reed and see what our Court of Appeals said. Our Court of Appeals held that a search must be incident to an actual arrest, not to probable cause that might have led to an arrest but did not. Now we're talking about custodial arrests. Thus, the police must either make an arrest or intend to make an arrest at the time of the search in order for the search to be considered lawful. In this case, the officer testified that he stopped the car believing the defendant who was driving was intoxicated. However, he testified, although he made the stop, he did not intend to arrest the driver for intoxicated driving. Has anyone experienced that in any of your cases? An officer stops a car but testifies he did not intend to make the arrest. Well, this officer testified clearly he did not intend to arrest for DWI. However, the officer then frisks the driver and finds a knife and makes the arrest. The people, in this case, only argued that the frisk was incident to a lawful arrest and therefore legal. The court said no. Without an actual arrest or at least an intent to arrest for DWI, the frisk was unlawful. And the court relied on a Supreme Court case, Knowles versus Iowa, where the officer there had probable cause to stop the car for speeding, issued a citation for speeding, then after that searched the car, found marijuana. The court held that search was unlawful because once the citation was issued, the search incident to the arrest was not justified because the concerns that justify such a search no longer existed. So now comes Diaz, the Second Circuit case. So what are the facts in Diaz? Well, this was a vertical patrol. The officer is walking up the steps during the vertical patrol. She smells marijuana coming from one of the landings. She climbs the stairs, gets to the third floor. There, the defendant is holding a red plastic bag and sitting next to a bottle of vodka. The officer testified she intended to issue a summons, but not to make a custodial arrest. She intended to issue a summons for the open container, but did not, because before she could do that, the defendant started fumbling at his waist area, causing her concern for her safety. She conducted a frisk, found a gun, and then makes the custodial arrest. The gun recovered was lawful, the Second Circuit said, under the search incident to an arrest. The Second Circuit held, and this is where the Second Circuit disagrees with our Court of Appeals, if the officer has probable cause to arrest, which he did, but does not do so initially, because of evolving circumstances, frisks and finds a gun, then makes the custodial arrest, the seizure is proper. And the court in Diaz points out our Court of Appeals interpreted Knowles incorrectly. The bottom line is that even, according to the Second Circuit, even if an officer has no intent to make a custodial arrest, as long as an arrest is made by the end of the encounter, the recovery of the contraband is lawful. So that's the disagreement there. One other case by our lower courts, following Reed, of course, is on page 11, the Simmons case, where the complaining witness informed the police that she had been, the defendant had assaulted the complainant. So the police approach the defendant with the intent to verify if this person is the one described by the complainant. The officer notices a knife sticking out of the defendant's pocket, retrieves it to see if it was a gravity knife. It was not until after the officer retrieved the knife that he first asks about the assault. The court said, this is the First Department, the people did not establish at the time he recovered the knife that the officer intended to arrest for the assault. Therefore, the knife was not incident to an arrest, but it was remanded to determine the issue raised by the people, whether the seizure was a self-protective measure. Now, one question that's frequently asked on this topic is, well, why couldn't these bags be searched pursuant to the booking procedure at the precinct? Why does it have to be a search incident to an arrest? It could be, certainly, but in all these cases, the officers do not wait till they get to the precinct. They search the bag, according to the decisions, immediately. But even if the officer chose to wait to the precinct and conduct this type of inventory search, it's a very standardized procedure, and in the outline I've put some cases where, again, the prosecutor did not elicit enough testimony to establish that there was a proper inventory search at the booking procedure. Okay, so let's talk about emergency searches as an exception to the warrant requirement. Certainly a very important exception to protecting life by assisting victims of crimes. So we have two cases where the Second Department suppressed evidence, finding that the emergency search exception was not, in fact, lawful. The first one is on page 12, the Williams case. Here, the police responded to a report of an assault in progress and a possible firearm being used. So the police arrive. Defendant then runs into a residence. The complaining witness said, the defendant just assaulted me. He used a pipe. He used his fists. He used a bat, and he had a gun. So the police go to the door of the residence into which the defendant has run. The defendant's mother is outside saying, my children, some children are inside, you have to go in and help them. So the police kick the door in, they find the defendant, they handcuff the defendant, they search, they're looking for the children. They find the children, they safeguard them, they're in a rear bedroom. They do find a pipe in the stairway. They find a bat in the backyard. They search the basement, but they do not find anything else. So they bring all of this outside to the sergeant. He says, wait a minute, guys, there was supposed to be a gun here. Go back in. They go back in, they go into the basement, and they find a gun. That's the search that was bad. The evidence found initially was fine, but the second search was improper. The first search was justified by the emergency exception. Once the defendant's in handcuffs, once the children are safeguarded, everything is fine, the emergency has abated. Therefore, the second search exceeded the duration of the emergency, and any evidence recovered, namely the gun, had to be suppressed. The second case is the Ringel case, I think on page 12. Here, the court suppressed because the prosecution failed to establish the threshold requirement for an emergency search, that is, that there was an emergency. And in Ringel, Nassau police officers received a report of a silent alarm in a home in Woodmere, Long Island. The officers testified that in their experience, such alarms are frequently false, but they're told to go anyway. When they arrived at the house, Ringel is in the driveway working on a van. He's underneath the van. There's no sign of any break-in. The defendant says, "I'm sorry, I must have triggered the house alarm, accidentally. The house belongs to my parents. Everything's fine." They say to him, "Well, let me see some photo ID." He cannot do that, but he shows a credit card with his father's name on it. And he shows them a set of keys. He said, "These are the house keys." They say, "Look, we need to get inside to see, we got an alarm, we need to see if everybody's okay inside." So the defendant becomes rather nervous and agitated and tells the police, "Look, you can call my sister, she'll tell you who I am. We don't want to talk to your sister, we have to get inside." So he takes a set of keys and he takes one key and opens the door of the house just slightly. He says, "You see, it opens the door." With that, they push their way in. And they find quite a lot of contraband. 2 hand grenades, explosives, 10 pounds of marijuana, guns. I think even the Lindbergh baby was in there. But all of that is suppressed. The court holding that the facts, as known to the police, did not provide a reasonable basis to believe that an emergency was at hand. The alarms were, as the officers testified, usually false. Defendant's working on a van. He has the keys to the house. He has a connection to the home, gives them his phone to speak to his sister, and there's no sign of a break-in. A reasonably objective standard, that is not an emergency. Okay, consent. A case on page 13, the Freeman case underscores, this is coming out of the Court of Appeals, underscores that before a person can give consent to search his or her home, it's got to be knowing, voluntary, and intelligent. That's pretty basic. Defendant's in his house under arrest. I won't bore you with the facts that led up to that, but he's in his home under arrest, sitting in a chair. They want consent to search his basement and a room in the house because they believe there are drugs there. There's no evidence that he's familiar with the criminal justice system. He's sitting in a chair. He's got his hands behind him, handcuffed in the chair. He's shown a consent form. The police do not read the form to him. It misidentifies what is to be searched. It misspells his name. There's no evidence that he ever read the form. And the court held, it's a no-brainer, the court held, I think, that this is not a voluntary consent. What is unusual is they reversed the Fourth Department. The Fourth Department held that this was, although it was 3-2, that was a voluntary consent. That's what was strange about the case. Okay. So let's talk a little bit about automobiles. So as far as car stops go, we're seeing now in decisions stops based upon information that is not so much being transmitted by the police, but or where the source is the police making observations. We're having people riding in their cars on their cell phones, probably unlawfully, making observations about other people cutting them off, weaving in and out of the lanes, and they're getting on their phones, calling the police, calling 911, giving information about other motorists. And this is some of the cases we're seeing now. The question is this information coming from cell phone users valid and does it justify the car stops? Well, there are a couple of cases on page 15 in the outline. One with the Wisniewski case, where the caller is identified, there is certainly sufficient reliability, the court said, to support a stop by the police based upon a reasonable suspicion. In the more challenging question is, in the Arias case, where the caller does not give his or her name, is that reliable enough? Well, the First Department held in that case it was. The reliability of that information could be justified based upon the fact that the call was potentially traceable and that it was in the form of a present sense impression. The Driscoll case on page 15 is a case involving a routine VTL stop, and it reminds us that an officer may not make a VTL stop based upon, quote, whim, caprice, or idle curiosity. That's the language they quote from a very old case, People versus Engel, 40 years ago. The officer testified that whenever he observed a car driving by with a temporary inspection sticker, he would stop the car because he was curious. He just was curious, you know. He just wanted to know if the sticker was valid or not. You know, people get curious, you know. Well, the court said, no, wait a minute, this is idle curiosity and was not a basis for stopping a car. And the drugs in the car were suppressed. But it's interesting, the reason I mentioned Driscoll is Driscoll raises the question, what is the correct legal standard for a routine, benign VTL stop? And first, Driscoll cites Engel, and it uses language, both reasonable suspicion and probable cause. Now, some appellate courts around the state continue to use reasonable suspicion, some use probable cause. Now, we're not talking about a car being stopped for criminal activity. That would be, obviously, reasonable suspicion. This is just a violation of the vehicle and traffic law. And I happened to catch a CLE online a month or two ago where the CLE lecturer said the following: Engel isn't good law anymore. Well, respectfully, I think that's incorrect. Engel has never been overruled by the Court of Appeals. It was cited this year in the Bushway case that I mentioned earlier, the plate reader case. It was cited. But there certainly is confusion about the correct standard. Engel, 40 years ago, posited a reasonable suspicion standard. You may remember the Robinson case about 15 years ago where the court used a probable cause standard for a VTL stop. But it was used in a case with a very discrete issue. In that case, the issue was if an officer makes a pretext stop, and in those years, everybody was raising the issue of pretext stops. So that was put to an end by Robinson. So the issue there was if an officer makes a pretext stop and has probable cause to believe that there's a violation of the VTL, is the car stop valid? And the court said yes. But after Robinson, many courts started using probable cause as a standard. Other courts still used the Engel standard. It's never been decided, this issue has never been nailed down by the Court of Appeals. But clearly Engel is still good law. And as I would quote Judge Marcy Kahn, who's now in the appellate division, who many years ago said, if the Court of Appeals intended to overrule Engel and Robinson, it would have done so. It didn't, and Engel is still good law. So I just point out there is still confusion about this topic. I want to mention an inventory search case on page 18, the Lee case. Inventory search is always interesting, and it's a good illustration that in evaluating an inventory search, courts are not prepared to elevate form over substance. Now, if you read this decision, the dissenting judge wrote in meticulous detail about the officers not following the exact requirements of the patrol guide in conducting an inventory search. And if you do go to the patrol guide, there are page after page of requirements of how to conduct it properly. You've got to search the car's interior thoroughly, only forcing open a compartment such as a trunk under certain conditions. And then once you remove the valuables, there are certain forms that have to be filled out, specifically delineating the forms. As the majority points out, the officers substantially complied with the criteria of the patrol guide, but not 100%. But although the police did not technically comply with every requirement, they substantially complied by compiling a handwritten list of all the property removed. And the fact that there were minor inconsistencies between the handwritten list and the property clerk invoices did not call into question the validity of the search. Now, there's one type of car search that is relatively new that has come from our Court of Appeals, and that is a search conducted under what's called the community caretaking function. Now, this is the Tardy case on page 19, and this was a search first mentioned by the United States Supreme Court 50 years ago in a famous case, Katie versus Dombrowski. But it somehow never reached our Court of Appeals, but now it has. What is the community caretaking function? It's a function that's totally devoid from detecting evidence, investigating crimes. It's one of these calls the police get, my cat is up a tree, can you help me get the cat down? Answering complaints about injured animals, things like that. That's the nature of the function. So, in Tardy, the defendant was arrested for shoplifting in a Target store upstate. He's arrested outside the store, and the security personnel were speaking to the police and saying, look, we know this guy, he's been around here before, he shoplifted, his car is parked here in the parking lot, we don't want his car, would you just get it out of here? And the police decided to accede to that request. So in order to do that, they had to impound the vehicle, and obviously, as part of the impounding procedure, they had to inventory the search, and they found a gun. So the question was whether the recovery of the gun was valid. The court upheld the decision to tow the vehicle and conduct the inventory search, holding that upon the defendant's arrest, the vehicle would have been left unattended indefinitely in the parking lot, which had a history of vandalism. And they said the decision made by the police was a reasonable one under some public safety type of theory and came within the parameters of this new community caretaking function. There was no motivation by the police to discover evidence of any criminal activity. Judge Rivera was the lone dissenting judge, and she said, is this what we really mean by community caretaking? Look, she pointed out there was no threat to any public safety. The vehicle was parked unobtrusively, not creating a hazard. But again, she was the lone dissenting judge. The last thing I wanted to mention, just to keep your eye out for one issue as it keeps percolating through the system, it's the issue of police officer credibility. It's sort of been making the news recently, and there are a number of decisions written by courts, suppression courts, finding that certain officers were not credible, certainly not indicating a majority of officers, some officers. But there was a forum at the city bar about a month ago. We sort of opened up a dialogue about it. And then Judge Weinstein in the Eastern District, if you may have read in the Law Journal, will be holding a hearing in January on this very issue. He has felt that it's an issue that requires a full-scale hearing, sort of on the scale of the hearing that Judge Shinlin did a number of years ago on stop and frisk. So just keep your eyes out, keep your eyes open for that issue. I think it's something that will be appearing more and more in the news. So with that, I thank you. And any questions? Or yes, sir.
On the case where the officer opened the defendant's bag in front of the car, it seemed to me a search instant to arrest or abandoned property. I don't understand why those...
I don't think the abandonment was raised by the defendant in that case. The question was whether the, we have some mics, but anyway. The question was in the case where the bag was placed on the car and there were no exigent circumstances, why not abandonment? The abandonment was not raised by the defendant, and so that the court never reached that issue. Yes, sir. Yeah, we'll wait for the mic so that...
Going back to the cell site towers.
Has there ever been an argument
a person's location at any particular time and place isn't private in the first place? That just by being somewhere?
Yes, as a matter of, you mean, in public, you mean? Yes, as a matter of fact, in the Hall case, in the first department was raised, and they said that that's a valid argument the prosecution made, yes. But that's one of the issues the Supreme Court's going to hear. Okay? Anyway, thank you very much for your time.